And Eugene, hello. How are you?
I'm doing great. How are you?
Fine. I guess we have to introduce ourselves to the folks at home.
That's right. I'm Eugene Volokh. I'm professor of law at UCLA Law School. I teach constitutional law here. And who are you, Jack?
I'm Jack Balkin, and I teach constitutional law at Yale Law School. And today we have a very special edition. It's the special Bill of Rights edition, in which we will cover exactly two of the amendments in the Bill of Rights.
That's right. That's right.
There isn't time for any more.
No, you could spend many hours covering the others. Probably many hours involving other people who are specialists on this, but we know the First and the Second Amendments pretty well. So
we've also decided that we will cover them in backwards order.
That sounds great.
We're going to start with the Second Amendment.
Just to keep it interesting.
We're going to start with the Second Amendment, then we're going to do the free speech clause of the First Amendment, then we're going to do Establishment Clause, then we're going to do free exercise, and then we're going to end with the very beginning of the Bill of Rights, which is the Establishment Clause.
That's right. The careful viewer will have noticed that not only doing two and then one, we're doing the clauses of the First Amendment in reverse order, though of course skipping the petition/assembly clause, which gets no respect.
If you want to, we can talk about petition and assembly.
No, that's okay. There's a reason it gets no respect. The Free Press Clause, of course, is often discussed implicitly together with the Free Speech Clause, and same with the Petition Clause. The rules are pretty similar on those, so that's why we're not going into great detail on it.
And we're going to do a free press issue right at the very beginning, because we're going to talk about the Fairness Doctrine, which is very much in everybody's mind these days. So let's first start talking about the Second Amendment, and as you know, there is a good chance that the Supreme Court will finally take a Second Amendment case. It has not taken one. It has not decided one specifically about the Second Amendment, I believe, since 1939. Is that correct?
Yeah, that's right. That's right. And it seems quite likely the Supreme Court will hear this new case, called the Parker case, because there's now a split among the circuits, with some circuits saying the Second Amendment secures only a states' right or collective rights view, other circuits taking the view that it's an individual rights view. On top of that, you have a disagreement between the federal court that's in charge of D.C., the D.C. Circuit, and the D.C.'s own equivalent of kind of a state Supreme Court, which upheld the D.C. gun ban, while the federal D.C. Circuit struck it down. So those are pretty good, strong signals to the Supreme Court that it's time for it to step in and resolve these disagreements.
Now, you've written a great deal about the Second Amendment, right?
I've written a bit about the Second Amendment. By the time I came to the subject, most of the really important things had been covered. I found a couple of things that hadn't been covered that were worth discussing, but the lead work had been done by others, by a fellow named Don Cates, who's a practicing lawyer who wrote about it in Michigan Law Review in 1983, then by Nelson Lund at George Mason, who wrote an article about it in 87. Others covered it as well, but one of the most important articles on the subject was written by your former colleague and your frequent collaborator, Sandy Levinson, a professor of law at Texas Law School, who published in the Yale Law Journal in 1989 an article called The Embarrassing Second Amendment, which took pretty much an individual rights view. At the very least, it's a highly credible case for the individual rights view of the Second Amendment. But it came in a leading law journal written by one of the leading liberal commentators. So that's the kind of man bites dog story that catches attention. And it was a very well-written piece and really helped change the debate.
Right. And now, also, it's important to understand that Sandy was looking at one of the two major strands of individual rights arguments for the Second Amendment. So first, let me just explain to the folks at home that you can have either a collective rights view of the Second Amendment, which says that it's primarily guaranteeing the rights of states to run their militias, and therefore there's no individual right. And then there's an individual rights theory that says that the Second Amendment guarantees an individual right of some kind, but there are different justifications for the individual right. It could be a civic Republican theory or a self-defense theory. In fact, the self-defense theory is actually intimately related to the civic Republican theory. But the civic Republican theory is the one that has least purchase for most people today. It's the theory that says that you need an individual right to bear arms in order to get together with your friends someday to overthrow a tyrannical central government.
Or better yet, deter the central government from getting that tyrannical in the first place, so that'll be sort of a win-win situation. Yeah, it's something that moves some people today, but I think not a lot of people, not even a lot of people who really do believe in individual right to keep and bear arms. I like, even setting aside the constitutional view, I like the idea of having guns for self-defense, but really that's what's important to me, is self-defense against criminals. I don't worry as much about self-defense against the government, partly because it's pretty hard to defend against the modern military, perhaps not impossible, but pretty hard to defend against the modern military with small arms. And second, I just would really like to imagine, and I think there's good reason to imagine, that we don't actually need to do that. We've had a pretty good track record of government maybe getting wrong-headed in various ways, but not the sort of oppression that warrants a violent revolution. At the same time, it's important to realize that the Second Amendment was drafted by people who had just engaged in a violent revolution against the government, which by today's standards, by the way, wouldn't be a ridiculously tyrannical government, whatever they said about King George. King George is no Stalin or Hitler or even Mussolini. They were quite comfortable, though, with the concept of violent revolution, if when necessary, to stop government tyranny, and violent revolution which was facilitated by private gun ownership and also private experience and familiarity with guns. So it's true, it was written in a very different time, in a time when you look at the contemporaneous documents, they talk a good deal about right to bear arms as a means of deterring government tyranny. They don't talk much at all about right to keep and bear arms as a matter of individual self-defense. Maybe they just took it for granted, but it didn't seem to have been the sort of thing that was at the forefront of their minds.
These ideas nevertheless are related, because the civic republican theory is based on the idea that if the government starts behaving like a criminal or a tyrant, then people can band together to resist. And then if private parties are violating your rights, for example, because they're criminals or because they're bullies, you can use the right to bear arms to protect you from that kind of overarching power, that kind of tyranny. So from the standpoint of the late 18th century, the distinction between public power and private power is not as sharp as we might think about it today.
Yeah, that's right. Relatedly also, people who are familiar with the use of guns for private purposes, including private self-defense, but also even for things like hunting, are people who are more likely to be able to use guns in a military context. There's a fascinating story on NPR, of all places, from several years ago about snipers in the American Army. And as I understand it, being a sniper is really a remarkable skill. It requires much more than the sort of ability that most of us have. It's kind of like being a world-class runner. You know, any of us can learn how to jog, even if I, for example, utterly refuse to. But to be a world-class runner, you need something special. And for snipers, one of those special things is often experienced from childhood, usually hunting. So in any event, there are connections between private gun possession and public gun possession as a means of either deterring government tyranny or more effectively fighting wars. The other thing I think is that there's just a general attitude that goes hand in hand with both opposition to private ownership of guns for self-defense and with real resistance to the notion of private resistance to tyrannical government. It's sort of, you think of it kind of as a pacifist approach. The framers were no strangers to pacifists. They lived around pacifists such as Quakers. There were some controversies about the Quakers' pacifism. And I think the framers took the view that, you know, while certainly lethal power can be and often is abused, that people ought to be prepared to use lethal power when necessary. And the notion that you are prepared to use lethal power against criminals is indeed closely connected, I think, in people's minds to the notion that it's also legitimate to use lethal power against criminal governments.
Now, the argument that I think that would probably resonate with more Americans today is the individual rights argument based on self-defense. And the pedigree of that argument is not so obvious in the late 18th century as it is during Reconstruction. And it's important to understand that with Reconstruction, the 14th and the 14th Amendment, the question becomes whether or not blacks, newly freed blacks, had the right to arm themselves to defend themselves against what is essentially terrorism, by members of the Klan and other people who were opposed to equal rights for blacks and wanted to restore them to a condition of slavery. And so you see in the debate surrounding the 14th Amendment a series of arguments that one of the purposes of the amendment is to guarantee equal citizenship for everyone, and particularly for blacks. and that one of the elements, one of the privileges or immunities of being a citizen of the United States is the ability to bear arms, not simply to overthrow a tyrannical government, but also in self-defense, especially in a condition...
That's exactly right. And I should just add the Freedmen's Bureau Act that Congress enacted shortly after the end of the Civil War explicitly referred to the constitutional right to bear arms as a means of stopping private violence, though indeed, as it happens, the Klan, often the private violence was with the connivance of local authorities. Also, if you look at state constitutional provisions, because 44 of the 50 states have state right to bear arms provisions, at least 40 of those are clearly individual rights provisions, either as written or as interpreted by courts. But if you look at the state, at the text of the state provisions, around the framing, some of them talk about right to keep and bear arms in defense of themselves and the state. The themselves seems to suggest private self-defense, and the state means is probably a reference to private gun ownership, but with a collective purpose. But then you look through the 1800s, for example, in your very own state of Connecticut, its first constitution was not around the time of the framing, but in 1818, and it talks about every citizen having a right to bear arms in defense of himself and the state. Even more clearly, a reference to private self-defense. And throughout the rest of the 1800s and 1900s, lots more state constitutional provisions added that are clearly aimed at self-defense, and lots more talk in court decisions about the right as just being, among other things, a right to defend yourself against criminals.
So some of you at home may be asking the following question. If it becomes clear by the time of Reconstruction that the Second Amendment contains an idea of self-defense, but it's not as clear, although the evidence is mixed, that it contains such an idea at the time of the founding, what happens then in a case in District of Columbia, which is a territory of the United States and it's not a state? Because the 14th Amendment, by its terms, restricts what state governments can do. And the argument would go something like this, that there is some evidence that the principle behind the Second Amendment, which applies against the federal government, was both the civic republican theory and the self-defense theory. There's a stronger view that at the time of the 14th Amendment, the folks who drafted the 14th Amendment understood that the right to bear arms was a privilege or immunity of citizens of the United States generally, and that regardless of what the 14th Amendment says in its relationship to states, it is clear that by the time of the 14th Amendment, people generally accepted that the privileges or immunities were privileges and immunities of national citizenship were a fortiori binding against the federal government as well as the states. So if you wanted to make that kind of sort of reverse incorporation argument, and my colleague Akil Amar has made it, that's the way you would do it. But I think a lot of people, Eugene, will want to know the most important question, for them will be this. Suppose that we said, or suppose the Supreme Court said, after all these years, that the Second Amendment guaranteed some kind of individual right, and it rejected the purely collective rights view that's been in vogue for many, many years. What effect would that have on gun control legislation around the country? Would it mean that all gun control laws are unconstitutional? Would it mean necessarily that the District of Columbia's law was unconstitutional? That is, what follows as a consequence of accepting the theoretical proposition that the Second Amendment protects an individual right?
Yeah, that's the great question, and rightly so, because there are lots of theoretical questions about law, but ultimately law is a practical discipline that's about actually affecting what people and governments do on the ground. So let's assume that the court says, yes, the Second Amendment is secures an individual right. That was actually a view that was at least suggested by the court throughout parts of the 1800s and the early 1900s. The Miller case in 1939 is ambiguous about it. So it would reverse the dominant view among federal circuit courts, but wouldn't really change so much the Supreme Court case law, in this because Supreme Court case law is scant and ambiguous in some measure, and at the very least pretty old. But let's assume then the next step, which is that the court later says that the Second Amendment also applies against state and local governments by incorporation into the 14th Amendment. Recall that in the 1870s, in the Cruikshank case, the court expressly did hold that the right to bear arms doesn't apply to states. That was a clear and square holding, at least the federal Constitution's right to bear arms. But at the same time, it held the First Amendment didn't apply to states. That was before it applied anything to any of the Bill of Rights to states. So it may very well be the court will say, well, given the body of case law applying the Bill of Rights to states, the Second Amendment ought to be included. Let's say that happens. What then? My view is that probably this means that most relatively modest gun controls, whether you think they're a good idea or not, but they will be upheld as constitutional so long as they're seen as mere regulations rather than prohibitions. And I think the framers would have recognized the propriety of that. The framers did not generally view rights as categorical bans on government action. Some jurisdictional decisions they viewed as categorical bans, but generally not things like the freedom of speech, which the framers recognized. There were exceptions for libel. Shortly after the framing, there were recognized, although I think wrongly, exceptions for blasphemy. There were, throughout much of American history, exceptions for criticism of courts in pending cases and the like. So the framers didn't see the First Amendment, the freedom of speech, for example, or its analogs in state constitutions, as categorically protecting all speech. Likewise, I don't think they would have seen the right to bear arms as categorically prohibiting all gun controls. When it comes to bans, either bans on all guns, the D.C. ban, for example, says you can't have any handguns, and rifles and shotguns you have to keep locked and unloaded. Or just bans on handguns, which is the case in a few cities, Chicago chiefly and its environs. Those kinds of categorical bans on a large category of guns would probably be unconstitutional. So those laws unconstitutional, things like waiting periods, things like registration requirements, restrictions on felons possessing guns and the like, I'm almost certain would be upheld. And we have actually a good deal of track record on this from state courts in applying state constitutional rights to bear arms. By and large, regulations are upheld, but when a ban becomes severe enough, it tends to get struck down. Interestingly, some of the most interesting case law on this comes from Oregon and Washington State, not the sort of places that you might think of as heartland of gun country. But Washington courts, for example, have dealt with the question of what happens when you try to enhance a criminal's punishment because he has a gun. So there are laws that say if you're committing a crime, your sentence will be even greater if you possess a gun in connection with the crime. And the courts have said, look, that's perfectly fine as a general matter because that prevents criminal misuse of guns, and that's all right. That's not protected by the state right to bear arms. But when it comes to somebody, for example, being prosecuted for possessing or dealing marijuana, and he happens to have a gun somewhere in his home, far away removed from the transaction, you can't then say, oh, he had a gun, and therefore enhance the penalty, because that's punishing somebody just for possession of a gun, which is something that's protected by state constitution. So courts will have to make these kinds of decisions. Generally, I think they'll make them with a good deal of deference to legislatures that are trying to regulate guns. But when it looks like it's a ban on guns or punishment for possessing a gun, just possessing it even for innocent purposes, then in that case, they're more likely to say that's unconstitutional.
Notice that this argument you're making, reasonable regulations of guns will still be permitted, even if we recognize the Second Amendment as an individual right, makes much more sense if you think that the purpose of the right is self-defense than if you think the purpose of the right is to allow people to overthrow a tyrannical government.
Well, I'm not sure that's right, because here's an example. Let's assume that we accept that part of the purpose of the right is to allow people to deter a tyrannical government. A waiting period for buying guns would probably be constitutional under that, because that doesn't materially affect people's ability to possess guns as against some future harms. Interestingly, the waiting period might pose more of a problem under the self-defense view, especially if there's particular reason for the person to fear crime right away. Say it's a woman who is left in an abusive relationship and she says, this man, my ex-boyfriend has threatened me with death. There, her claim to avoid a waiting period would be stronger under the self-defense view than it would be under the deterrence of government tyranny view. Because for purpose of deterrence of government tyranny, whether people can buy guns right away or have to wait 3 weeks doesn't really matter much.
Yes, that's certainly true. And with respect to many of the regulations, we can play them out either under the civic republican or self-defense. I was thinking rather of the kinds of weapons that one would be allowed to hold and possess. I think that there is a marked difference in some ways between what you would need successfully to provide the deterrence necessary to check the federal government and what might be useful for you for self-defense.
Yeah, there you're absolutely right. So, for example, a ban on fully automatic weapons doesn't much affect people's ability to defend themselves. It's only in extraordinarily unusual situations would you even want to have a fully automatic weapon. which in many ways is less accurate and more likely to run you out of ammunition right away in a normal self-defense situation. But if you are talking about deterrence of government tyranny, it would help if the citizenry would be armed with the kinds of weapons that are routinely issued to soldiers. So I think that's right, and that may be a reason why if the court wants to not completely ignore the Second Amendment, but wants to provide a somewhat sanitized version of the Second Amendment, the individual rights view may be more appealing to it, because it said, look, we can live with the individual rights view without changing that much. Indeed, under the individual rights view, nearly all federal gun controls and nearly all state gun controls would still be okay, because in America, by and large, in most places, you do have an individual right, even if not secured by the Constitution, but secured by positive law. You do have a right to possess a gun. So that wouldn't be that radical a step, whereas when it comes to the question of whether people can own fully automatic guns or possibly even more serious weapons, then there I think the court may be more likely to blink and say, hey, we'd like to come up with some interpretation that doesn't take us there.
What do you think the odds are, then, that the Supreme Court will take the Parker case and then will basically make a clear statement that there's an individual right under the Second Amendment?
I think there's a good chance of that happening. I think it's far from clear. I think a lot depends on where the justice is in the center. Kennedy, maybe in some measure Breyer and Souter and Roberts and Alito as well. I think they're all in play. But Kennedy in particular, which way he would go on that. You look at the court's decisions from the last term. Kennedy was batting .970. He was in the majority in all but two, he voted with the majority's results. Sometimes he had a separate opinion. In all but two of the 70-odd cases that the court decided. He is the man who is the swing voter on the court right now.
That's right.
So where he goes, chances are, not always, but
have you spoken to him recently about his views on the Second Amendment?
I have not spoken to him recently on the views of the Second Amendment. I don't think it would have been quite proper for me under these circumstances to speak to him. And if I did speak to him, I'm pretty sure he wouldn't want me to tell the world what he said.
All right.
Which I didn't.
All right. Okay, we are back, and we talked about the Second Amendment, and now we're going to talk about the First Amendment, and in particular the free speech and free press clauses. Now, one thing that's been in the press recently, been a lot of coverage, not only in the press, but also in the blogosphere, and Eugene and I are avid bloggers, has been the possibility of the return of the FCC's fairness doctrine. Now, I believe yesterday the chairman of the FCC said there was very little chance that he was going to reinstitute it or push for its reinstitution, but several Democratic senators have suggested that it might be a good idea, and then that was met with a great deal of howls of protest from people on the other side of the aisle. And so one thing we might want to talk about a little bit is the policy issues behind the fairness doctrine, and also how the media have changed and whether or not the fairness doctrine really would make any sense anymore if we were to bring it back. And then, of course, we can say a few words about its constitutionality.
Yeah, go on, Jack.
I think I just start by telling folks, so they understand where I'm coming from, that I am not convinced the fairness doctrine is unconstitutional, since my view generally about regulation of telecommunications suggests that some versions of it might be constitutional. On the other hand, I think it's very bad public policy, and I would oppose it being brought back. I think that we live in a time in which the last thing we probably need is a particular form of regulation like the fairness doctrine, which doesn't mean, however, that I think that related doctrines like the equal time provisions or the requirement of a sale of television time to federal candidates are unconstitutional or are bad policy. I think those might be very good policy. I just think the fairness doctrine isn't a particularly good one.
You know, just so that viewers don't think this is a setup job, generally speaking, Jack and I are politically pretty far apart. He's a man of the left, and I'm a man of the right. Probably both of us are sort of center-left in many ways.
I thought I was a reasonable guy.
Exactly.
And then what
so
were
a
you?
reasonable man of the left, and I'm a reasonable man of the right. But on this, I think we agree on both parts of it. I think the fairness doctrine, as written, not necessarily as implemented, but as written, would not be necessarily unconstitutional, and versions of it might be constitutional. I also think that the chief problem is it's bad policy. A little bit of just to step back, one reason it's so fascinating by the fairness doctrine that we wanted to use it as the one thing we'll talk about in the free speech press context is there's so many different First Amendment issues that come up here. One has to do with the deterrent effects, the so-called chilling effects of even well-intentioned laws. So the problem with the fairness doctrine isn't so much, or at least isn't just that, well, it's bad to be fair. Well, it's good to be fair. It's an interesting question whether we should mandate fairness, but you could see the benefits of fairness. But the problem is that since the fairness doctrine means that once a broadcaster allows some commentary on controversial issues, it has to allow commentary on the other side. That creates a deterrent effect.
That's not quite right. The fairness
tell me
doctrine.
what it is then.
The fairness doctrine has two prongs to it. The first prong of the fairness doctrine requires that licensees, broadcast licensees, radio and television stations, but not cable programmers, mind you, they have to give some coverage of important issues of public concern. That's the first prong. That is, you can't just spend all your time with pop music and sports and worldwide wrestling.
But the reason that I said
and
that
the
aside
second
is,
prong.
Yeah.
Wait, let me finish. The second prong is that when you cover these issues of public concern, you have to cover them fairly, giving attention to different perspectives on them. Now, all the problems with the doctrine come in how you articulate the second prong. But I should point out that the first prong itself could be understood by some people as an imposition on their free speech rights. Why? Because let's suppose I happen to have a station and all I want to cover is pop culture and pop music, and I don't really want to cover the news because people find it very boring and they don't want to watch it. But the fairness doctrine's first prong requires you to actually cover it. And what many stations did to avoid the first prong as much as possible was simply to exile discussions of public concern to Sunday afternoon at 3 o'clock in the afternoon when nobody else was listening, and that's what or at 6 o'clock in the morning on television shows right after the opening reveille. That's because a lot of broadcasters' business model was, we think that coverage of public affairs is boring. People don't want to find anything about it. How the world has changed.
TV is going to change that attitude, and everybody will instantly start to have a great desire to have people talk about, for example, the first two amendments. And I think every evening at 7 o'clock on every television station will be chiefly people like us talking about these things.
I'll perish the thought. But the reason I dwell on the first prong is because how different the world is now. When you have the internet and cable television, you suddenly realize that you have all these different niches. And these niches cater to people who want to hear about issues of public concern. And so we're flooded in some ways now in this particular media ecology with coverage of public issues. So that in that sense, the first prong of the fairness doctrine is no longer as important as it seemed to be in a period in which there were only a small number of television channels and radio stations in different jurisdictions.
Jack, but I do want to question a little bit about the first prong and also explain why I didn't focus on it. I think that by the late 80s at least, when the fairness doctrine was repealed, even right before it was repealed by the FCC, in practice, we had lots and lots of stations that provided a bare minimum, as you pointed out, of public affairs programming. Chiefly what they did is they had occasional news breaks in the middle of music. And I think a lot of people liked it that way. In fact, like it even better now that many of these stations don't have any news programming. Because if you want to listen to music, it would be classical, it would be rock, jazz, whatever else, you don't want to have a big debate intrude onto your listening pleasure. So as a practical matter, the FCC recognized that, and as a practical matter, therefore, most stations carried a bare minimum, often in the form of occasional news breaks, bare minimum of public affairs programming, and as a consequence, the real question is whether they would carry more. Whether some stations would say, we're not going to just do music or sports, we're also going to do more talk radio and other things, which in fact some people didn't want to listen to. And the problem with the fairness doctrine is it creates a very strong chilling effect on that. It deters people from putting on any kind of potentially controversial stuff because then people
that's the second prong.
They'd have to provide time to respond. Exactly.
Prong,
it is the second prong that is most troublesome, and I agree.
Yeah. The second prong, what it did, and Eugene and I both had blog posts on this recently, and we'll have the links later on. what it did was to say you had to cover, if you covered these issues, which you had to because of the first prong, you had to cover them fairly. Now, this created an enormous problem in some sense. It was easy to get around, but it nevertheless interfered with what you wanted to do. So, for example, let's suppose that you're Rush Limbaugh, and you do talk radio, and you want to deliver blistering attacks on liberals and feminists and the Democrats. Well, what the Fairness Doctrine suggested was that either you or somebody else that you appointed would have to provide the other side of what you were saying. Now, the other side is an amorphous category. What the other side of Rush Limbaugh might be somebody more conservative than him, or it might be somebody who's a little more liberal or much more liberal, or someone who's radical. It might be somebody who's offering a very thoughtful view, or it might be somebody who offers a rather dumbed-down view that, in fact, makes Rush look much better. And the Fairness Doctrine didn't tell you, really, which choice you had to make. It left a lot of that to the discretion of the broadcaster. So the effect of the Fairness Doctrine in practice was not really to guarantee a balanced coverage of news or public affairs. What it was simply an additional bureaucratic burden on broadcasters as to how they covered issues of public concern. It really had its greatest burden not for the middle-of-the-road or mainstream journalist who was used to the idea of covering both sides almost instinctually. That was the way one was taught to do journalism. It really affected those licensees that had strong beliefs about particular topics and wanted essentially to devote their broadcasting time to promoting those ideas. You might call them propagandists, you might call them single-issue broadcasters, but basically that's who it really most likely affected in practice. It really didn't affect the mainstream very much because basically their journalistic practices incorporated the Fairness Doctrine, and that was no accident because the folks who basically ran mainstream media were the same folks who basically came up with the ideas that led to the Fairness Doctrine in the first place.
That's right. So let's just step back a bit, though, to look at the legal and constitutional big picture. So there are three doctrines, at least, that are in play here. One is the doctrine that the government, when it runs its own property, has pretty substantial power to restrict, not unlimited by any means, but pretty substantial power to impose viewpoint-neutral restrictions on the use of its property. And
now, here you're basically going into the constitutional basis of the doctrine, right?
That's right, but I think I have to explain to our viewers, some of whom may say, Volokh, he's a libertarian. How could he possibly even suggest the Fairness Doctrine might be constitutional? I want to explain why I think it might be.
I understand you're a reasonable man of the right.
Exactly.
That's what I heard.
The government, when it runs its own property, does have pretty substantial powers that it doesn't as to purely private property. And rightly or wrongly, but not implausibly, the government took the view that the airwaves are essentially all of our property, and the government is acting as stewards for the airwaves and therefore has extra power to restrict what's said on the airwaves. That's why, for example, the Supreme Court unanimously struck down in 1974 a kind of very, very modest Fairness Doctrine for newspapers. It struck it down unanimously. And then 5 years before, in the Red Line case, the court upheld unanimously the Fairness Doctrine for broadcasters. It's this theory that it's a viewpoint-neutral rule that the government can impose in its capacity as owner of the airwaves, can impose on those people whom it allows to lease the airwaves for a time. So that's the constitutional principle, and I'm not wild about it because it does give the government a lot of power, but as a but I could see the reasons for it, that in fact, if the government picks and chooses who gets licenses, or even if it chooses it by the neutral process, but still not an entirely neutral process of figuring out who can pay the most for it, the government should be entitled to say, look, we're going to give you, but not a fee simple absolute, not complete ownership rights over this part of the spectrum, but ownership rights conditioned on your providing some access to others. So in principle, I can see that working. The problems are, first, this deterrent effect that we've been talking about, the famous chilling effect that the court has talked about in lots of other contexts, but there's also an implementation issue, that the trouble is the doctrine is so vague that either it ends up being left entirely in the hands of the broadcasters, in which case the mountains will have labored to bring forth a mouse, which pretty much is what had happened before. Or if you really do want the FCC or some other agencies to police it, they're going to have to try to do that in a viewpoint-neutral way and in a clear enough way, just something that's very hard to imagine. I mean, are we prepared, for example, to say every time some broadcaster covers something in favor of racial tolerance or racial equality or opposed to racism, they have to give equal time, or not even equal time, I'm sorry, the Fairness Doctrine never required equal time, but at least some material amount of time to the Ku Klux Klan. That if you say, no, the Ku Klux Klan doesn't get access, even though responsible speakers do, that's a viewpoint discrimination of the very sort the court has generally said is impermissible, even in government-owned fora.
I need to clarify something Eugene said. The Fairness Doctrine mostly would not require you to bring somebody else on the broadcast. You would have to cover it. You would have to say something like, some people disagree with this position that I'm saying. They say the following. So the broadcaster could, in fact, use themselves or their designated speakers to present the information.
But still, they would have to present in presumably some not entirely mocking way, or if they could completely mock it, then in that case that's a mockery of the Fairness Doctrine, would have to present the racist view. I imagine actually many a broadcaster would much rather have on a racist presenting the racist view than having one of its reporters or one of its editorialists.
What you would do is you would cut to a clip of some person who was very unsympathetic, and that person would then fulminate, and then you would just say.
So you really have a choice. You either have a Fairness Doctrine that has pretty much no effect at all, because people can game it by, for example, saying, I'm going to find the most extremist person and the least articulate and the most clearly foolish-sounding person on the other side, and I'm going to do that. And in a sense, that's just another way of further repeating my side. It's not really giving access to the other side. It's really a way of strengthening my own side. Or if you try to avoid it, if you want to take it really seriously, then in that case, you'd have to have the government constantly making decisions about which people are entitled to access, which people must be given access, and those decisions inevitably will be viewpoint discriminatory as applied, and therefore, even though the policy is in principle constitutional, in practice it is not. I should say, by the way, I agree with Jack that some much more modest policies, such as ones that require television stations to provide lowest cost or even potentially free access to certain well-defined group of political candidates, you might still argue that that's unfair to broadcasters, although I'm not sure it is. You might still argue about some implementation problems, but in principle they would be much more tolerable because they would be much clearer, much less vague, and at the same time much more likely to be implemented in viewpoint-neutral ways.
Right. I want to point out to folks who've been listening that one thing Eugene did not say is he did not use the magic word scarcity. The argument Eugene just made, and I would make a slightly different version of the argument for purposes of this discussion, it's not that important. The argument he made was not based on the fact that the airways are scarce. And that was the basis for the doctrine for many, many years in the Red Lion case. It was based on the idea that the airways are scarce, and therefore the government could decide how they were to be allocated, and therefore the broadcaster was public trustee. Now, in fact, you can make an argument for the broadcaster as public trustee, but it's not based necessarily on scarcity. The scarcity argument, in my view, has always been a spurious argument. And, of course, in the world we now have, with so many different media outlets, the idea of scarcity is almost laughable. But the argument that Eugene made, which I would make slightly differently and give it a few different bells and whistles, is not premised on the idea of scarcity. It's premised on the idea of government's control over resources that it either owns or is entrusted with zoning or delegating who gets to use it. And that's the basis, I think, the constitutional basis of the doctrine today, if it were brought in front of the Supreme Court, for example.
I agree entirely. I'd even, just one moment, ha 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 ha. That's me laughing at the laughable concept of scarcity.
Oh, I see. I understand. So that's okay. That was the jollity portion of this segment.
Exactly.
What do you think the political chances of the doctrine making a comeback are? I think they're actually rather low.
Yeah, I think they are pretty low. You know, I don't follow what goes on inside the Beltway much, but I take it that Bush would veto it. Of course, the situation may be quite different come January of 2009, but I think there would be enough opposition from enough pretty influential and credible sources, not just the Rush Limbaughs, but also a lot of people, including liberals, including a lot of new media people, that I think it's not likely to get enacted. What's more, my sense is that a lot of the push from generally speaking the left, which is mostly kind of the center left, for the Fairness Doctrine comes in part because of frustration about being now less out of power than they were before, but still out of the White House. So long as they're out of the White House, any proposal would likely be vetoed by even if enacted, would be vetoed by Bush. If they get that White House back, the veto won't be as much of a problem. But I think kind of this anger that leads people to say, how could it be that there are all of these horrible people on the airwaves and we allow this to happen without adequate response, I think a lot of that will go away too.
I don't think that the next Democratic administration would, in fact, try to pass the fairness doctrine. I think, in fact, this is an issue that some senators in the Democratic Party are raising. They're doing it partly to appeal to their base and, to some extent, to basically strike terror in the hearts of various broadcasters. But, in fact, I think most broadcasters don't take the threat very seriously. And for people like Rush Limbaugh, it's a wonderful way of showing that his opponents aren't very serious about freedom of speech. So, in fact, I think it's not the best strategy for the Democrats to pursue. I think there are a lot of strategies that the Democrats might pursue if they were really interested in promoting media diversity and making it possible for more people, as many people as possible, to participate in broadcasting and to make content available out there. They have to do with more general forms of telecommunication regulation and perhaps some kinds of reforms of internet regulation and also copyright regulation, something about which Eugene also has written a great deal. But many of them, they wouldn't necessarily involve something like the fairness doctrine. They'd be more structural in form.
Yeah, I should say I'm not wild about at least some of the structural reforms that are proposed, although, I think it may be constitutional, but I'm not sure they're a good idea. Well, why don't we move on to the religion portion of the material?
Yes, I think it's time for us to get some religion. So why don't you tell us a little bit right now about what's happening with the debates over free exercise in the United States?
Sure. So let's start with a quick big picture. Throughout much of American history, the Free Exercise Clause has been understood as saying the government can't single out religion for special punishment. So you can't have laws that, for example, which was pretty common in Europe before the American Revolution, and in fact in Europe and much of the rest of the world after, that say, look, we're going to ban the Catholic faith, or we're going to ban people from engaging in this kind of religious ritual precisely because it's religious. So throughout much of American history, the Free Exercise Clause was kind of a prohibition on deliberate attempts to suppress religion. Not always a perfectly enforced prohibition, but still actually on balance it did a pretty good job, especially by world history standards, of making sure that that religions weren't singled out for persecution. Nonetheless, it did tolerate what many religions found to be extremely burdensome, which are generally applicable laws that ban certain practice, including when it's done for religious purposes. So, for example, a law that banned the use of certain drugs, whether marijuana or peyote or whatever else, and had no exemption for religious practitioners. Now, at times, legislatures...
And a ban on polygamy, which was the other famous example.
Exactly. A ban on polygamy, which wasn't created in order to go after the Mormons. But when the Mormons arose, and at the time were supported polygamy, and saw it as an important sacrament, ended up very much burdening their practice to the point where essentially they were forced to change their religious practice. So throughout much of American history, there have been legislatively created exemptions from draft laws for conscientious objectors, exceptions from oath requirements, exceptions from prohibition when that was in place. That was seen as a matter for legislatures to decide. Then from the early 1960s to around 1990, the Supreme Court had this experiment with having constitutionally mandated exemptions, which is to say that if a religious objector had a religious objection, a sincerely held religious objection to a government action, chiefly a generally applicable law, he would be entitled to an exemption, usually. Now, of course, or at least presumptively. Now, of course, you can't really have an absolute scheme of religious exemptions. What if somebody feels a religious objection to murder law, or to theft law, or to the payment of taxes, or a variety of other things? So the court said, well, of course, if there's a compelling government interest in the law, applying the law even-handedly to everybody is narrowly tailored to that interest, well, then you can come up with an exception. But generally speaking, it ought to be, religious practice ought to be protected even against neutral laws. Well, it's interesting, this test, which is often called strict scrutiny, and which has been called in other areas like equal protection and free speech, strict in theory and fatal in fact, that was Jerry Gunther's phrase. Larry Sager and Chris Eisgruber labeled the religious freedom version strict in theory, feeble in fact. somehow when it came to religious exemption claims, most of the time, the Supreme Court and lower courts said, oh, there's a compelling government interest. They weren't really willing to take seriously constitutionally mandated religious exemptions. One of the reasons being that they would require, that kind of mandate requires courts on a case-by-case basis to decide how important various laws are. And how morally important they are and how practically important enforcement across the board is. So the court retreated from that. Congress then stepped back in with the so-called Religious Freedom Restoration Act, and some states did as well. And while there were some decisions on the federalism side of this, to the extent to which Congress can adopt it as to the states, today we have a regime in which the Constitution doesn't mandate exemptions, but federal law as applied to the federal government, state laws in about 12 states as applied to state governments, and state constitutional provisions in about a dozen states as applied to state governments do presumptively mandate these kinds of religious exemptions. So we've got this kind of experimental and mixed regime. And actually, I think on balance, it's a pretty good one. That we have a system now where in many places you can go to court and say, look, here's this generally applicable law. For example, a ban on helmets. A requirement that motorcycle riders wear helmets. Nobody thought about Sikhs who have to wear, because of the religion, turbans, and who cannot wear helmets as a result. Nobody thought about Sikhs at the time the law was implemented. So we want you, a court, to carve out an exemption pursuant to legislative authorization. The legislature has said it wants you to carve out these exemptions. And the court could then decide to carve out an exemption. And if the legislature says, no, we think it's just so important to mandate helmets for everybody, the legislature can step in and exempt the helmet law from the Religious Freedom Act's requirements. So it's an in-between position. It doesn't give what religious freedom activists want to everybody, nor does it give, nor does it implement what the kind of the hardcore no exemption people might want. But as a practical matter, I think it's a good mix where courts are entitled to, in kind of a traditional common law fashion, decide on a case-by-case basis whether certain kinds of exemptions are a good idea. But then the legislature ultimately decides for itself when even-handed enforcement, including to religious observers, is the right approach.
What's the hottest issue right now in free exercise law? And by the way, by free exercise law, I mean to include also these Religious Freedom Restoration Acts.
Yeah, well,
the Federal Act and also the state acts, little mini RFRAs they're sometimes called.
It's the tension between religious freedom rights and in some measure freedom of association rights and state and federal anti-discrimination laws. So for example...
So give me an example.
Say a landlord says, look, my religion tells me that I should not be an aider and abetter in fornication, which is sex between unmarried people, either generally or especially when it comes to sex between people of the same sex. You might think my religion is dumb. You might think it's immoral. You might think that it shouldn't treat renting to an unmarried couple as aiding and abetting. That's your view. My religion tells me, and for reasons that ought not be judged by secular standards of rationality. I mean, if you start judging religions by secular standards of rationality, you'll have no religious freedom protection left. My religion tells me that I ought not rent to unmarried couples or to same-sex couples. And this is an issue that's come up in several states, and the courts have gone different ways in those states. I think it's a classic example of where I don't think courts should have the final say, because there are two basic questions at the heart of this. First of all, is it basically just morally wrong to discriminate against people based on their marital status? Kind of like it's just morally wrong for somebody to steal somebody else's property. We don't give even narrow exemptions from theft law to religious objectors because we think it's just wrong to take other people's property. Is it equally just plain wrong to refuse to rent on a married couple or a same-sex couple because of its sexual orientation or marital status? That's the moral question. Also, the pragmatic question is, even setting aside whether it's wrong to do it on a case by in every case, is it pragmatically going to do interfere with the lives of unmarried couples or same-sex couples, would so cut down on their ability to find affordable shelter in the places they want that as a practical matter we need to apply this law even-handedly. These are very difficult questions, and questions on which reasonable minds may differ. And I think when it comes to religious freedom protections, which I think as a textual matter certainly don't mandate an exemption for religious believers, so at least it's plausible to interpret it as just a requirement of no no discrimination against religion, then it seems to me makes sense to say, look, let courts decide whether there ought to be an exemption, but then if the legislature says no, our moral and practical judgment is different, the legislature's judgment would trump.
One thing that I think that is relevant is that many fair housing statutes exempt relatively small landowners. That is, people who are just renting one room or renting one apartment.
Generally, if it's in a complex in which they themselves live.
Yeah, and so one way of basically accommodating different interests is by having exemptions for relatively small entrepreneurs. But if you own a large apartment complex or one that's primarily large commercial development, then in fact you have to apply the basic anti-discrimination laws that apply to everyone else. In fact, that's what was done, in fact, in the employment discrimination provisions of Title VII.
That's right. Though note why it might make sense to distinguish the size. One view that some people say as well, it's reasonable for people to object to same-sex behavior or unmarried sex by people who live right next to them, but unreasonable for them to object to the fact that one of their tenants 10 miles away is engaged in such behavior. That's not an argument that I think can carry the day here, because again, these are religious beliefs that some people do say, if I'm aiding and abetting sinful conduct even 10 miles away, that's still a sin for me. And I don't see how a secular court would say, well, no, that's not really a sin. Another view that some people say is, well, hey, if you're allowed to be a small-time landlord, but not a big-time landlord, well, it's not really a burden on you because, after all, you can just sell your properties and become a small-time landlord. Mm-hmm. Sort of the notion that, well, it's not a real burden on you because you can just change professions and change the line of business you're in, I think that misunderstands the concept of burden. That it's not a total prohibition on a particular practice, but saying you can't be in a particular line of work surely is a big burden. At the same time, if you think that there's a good reason, as a practical matter, to think that these kinds of decisions by large landlords are more likely to interfere with people's ability to find shelter, whereas by small landlords, chances are it's just going to be highly idiosyncratic decisions that are going to be pretty rare, then in that case you could argue that, well, there's a compelling interest in protecting landlords, a compelling interest in protecting people from the kinds of discrimination that can dry up all the housing available to them, and not a compelling interest in protecting them just against small-time, occasional, rare discrimination.
Yeah, and I suspect that if there's federal legislation ever included sexual orientation, for example, or ENDA, which is the Employment Non-Discrimination Act, were passed, it would probably have have exemptions for relatively small employers and landlords, precisely for the reasons that you've described. This is a legislative accommodation of conflicting values. Although I suspect most Americans today would not be particularly happy with the idea that you could refuse to rent to someone of a different race because you had religious scruples against doing so.
That's right. I'm not sure that there is a principal distinction between race and sexual orientation, and I think in a lot of these situations, I think the law ought to be made more friendly to landlord choice. I think that especially when there's no real problem with finding housing generally, despite one's race, I don't see why the fact that one or two landlords here or there want to discriminate ought to result in kind of legal barriers in the landlords choosing how to use their property. But that comes from my general libertarian principles. I don't think that's a constitutional mandate, especially one in the Free Exercise Clause.
Well, in fact, the point here is that almost all of this is going to be largely outside the Constitution anyway, because it's basically regulation of private decision-making.
Well, but it's outside the Constitution, except insofar as you interpret the Constitution as saying that regulation of private decision-making, especially religious decision-making,
right.
That is to say decision-making that is pursuant to what the decision-maker sees as a religious command, that's something that the courts ought to be the final policeman on. And I'm glad to see the court went away from having courts having the final say on the question of religious exemptions, but I'm also glad to see that some legislatures stepped back and said, well, we'll give courts a say, even though not the final say. So speaking of courts and religion and legislatures, you want to move on to the church-state questions?
I think it's time to talk about the Establishment Clause. And this, of course, is... so I should explain to folks that there are two big kinds of issues in the Establishment Clause that regularly come before the Supreme Court. they're sometimes called symbols issues and money issues. The symbols issues are issues about can you put a creche up in a public place? Can you have pictures of the Ten Commandments in a public location? Can the government engage in symbolic displays of religion?
Can there be crosses on the city seal of a city in New Mexico called Las Cruces?
Yes. And then the money issues are issues about largely whether or not the government can fund religious organizations, whether the government can have vouchers for parochial schools, whether the government can support parochial schools.
Including an even-handed program. So it's not like the government is selectively saying we will only fund parochial schools, but it includes parochial schools in generally applicable funding programs.
In theory, the governments could have programs funding parochial schools by themselves, but that would also be a money issue. It's important to understand, of course, that the distinction between symbols issues and money issues is kind of artificial because, of course, when the government places a large cross in the middle of the public square, it probably costs money to do that, and there is a certain symbolism attached to government support of faith-based initiatives, for example, which is one reason I think, in fact, some people oppose them because the amount of money is small, but the symbolism of the support, the connection between church and state for them is something that they're very concerned about. Nevertheless, I think that the distinction between the symbols questions and the money questions are really important, and it helps you understand why the doctrine developed the way it did. So, Eugene, what's the big issues these days? Are they symbols issues or money issues?
Well, in the last 10 years, they've been both. The Supreme Court, as to the money questions, has generally speaking, with some exceptions, but generally held that the government may include religious speakers and religious programs on an even-handed basis in even-handed funding programs. So, for example, if the government decides we're going to fund government-run schools, we're going to fund private secular schools, and we're going to fund private religious schools, and we're going to fund them pretty much the same level, or maybe even government-run secular schools more than the others, then generally speaking, the government is entitled to do that. But that was a 5-4
That doesn't violate the Establishment Clause.
That doesn't violate the Establishment Clause. 5-4 decision. At least generally speaking, there were 5-4 decisions, with Justice O'Connor providing the needed fifth vote, and in some situations actually saying, well, no, in certain so-called direct aid programs, even-handedness does not justify them. Now that Justice Alito has replaced Justice O'Connor, it looks likely like that those decisions are even more firmly fixed than they were before. Still 5-4, but 5-4 with the 5 more solidly taking that view than they were before. That seems pretty likely. We don't know for sure which way Justice Alito and Chief Justice Roberts would go, but boy, that's the way the smart money is betting.
And the Hine case, which was decided this last term, which is about a technical question of standing, nevertheless does tend to tip the hands of the justices about their position.
It does seem to point in that direction. Now, the symbols question, remember, this is the Ten Commandments cases from a couple of years ago. These questions keep coming up in lower courts. And there, the balance was even weirder. The Ten Commandments cases were 5-4 in favor of one display, 5-4 against another display. The court was badly splintered. It's not clear to what extent the previously existing test, which owes its origin to Justice O'Connor, the endorsement test, it's not clear to which it's even part of the law still. This is an area where I think it's pretty likely that if a case comes up to the Supreme Court, while the 5 current conservatives in the court are still on the court, the conservatives will be very happy to say, look, the old endorsement test, not right, was never practically usable. We've already retreated in some measure from it in the Ten Commandments cases. We're going to have a rule that allows the government to engage in religious speech, at least in certain contexts, like the Ten Commandments.
As long as there's no direct coercion of individuals.
Exactly. Now, here's the complicated thing, though. In the Ten Commandments cases, and by the way, I'm pretty firmly in favor of allowing religious institutions to participate in even-handed programs. I'm pretty strongly on that side. On the government symbolism situation, I'm a little more in the middle. I think on balance, I think the endorsement test is a bad idea, partly for historical reasons, partly for implementation reasons, but you could see a plausible argument that endorsing a religion as the better religion, and even endorsing religion generally, is a form of establishing it as the official religion. But here's the interesting thing. In the Ten Commandments cases, Justice Scalia said, look, Ten Commandments are okay, not because all government endorsement of all religion is okay, but because government endorsement of kind of the core traditional American monotheism, which is Christianity and Judaism and even Islam, all of them put together, for example, endorse the concept of a God in whom we trust. All of them endorse the Ten Commandments with some variation, but not very much variation. So,
by the way, Eugene, how did the Muslims sneak into Justice Scalia's vision of America at the founding?
Well, I think what Justice Scalia, when he talks about original meaning, he says, look, this was originally understood by the framing generation, and he doesn't talk about Islam there. But I think one of the extra selling points that he uses to pitch it to others is saying, look, this is a pretty broad coalition. This isn't just those people who happen to be running America in 1791. This is something that even Muslims today ought not be that troubled with. And to the extent there are a few people, atheists, agnostics, maybe Hindus and Buddhists, who don't agree with it, well, that's just part of the problem with being a very small minority. Is sometimes the government is going to express views that you don't fully agree with, and too bad. But he did seem to take the view that if you just have Christian symbolism, well, then in that case it's impermissible. Well, what do you do about things like Christian symbols on city seals, where, in fact, it's not an ecumenical God, the words God on the seal. Usually God is represented not through fully ecumenical references, but through things like a cross. Or what happens if you have a cross and a menorah to try to be ecumenical, but now the Muslims come in and say, well, where's the... What exactly? The crescent?
Where's the crescent?
I think the one thing they wouldn't say is, where is the picture of Muhammad? That's the one thing at least we don't have to worry about.
In most cases, that's not what they'd be saying.
So one wonders to what extent, even if the court says, look, endorsement of religiosity generally is fine, to what extent will even the majority coalition splinter then as to endorsement that uses specifically Christian, for example, symbolism, which a lot of endorsement does?
Do you have a view on this? Because I think this is an area in which you and I probably are not on the same side in a lot of these cases.
My tentative view is that as a general matter, for a combination of history, that historically, both in terms of original meaning and American tradition, a tremendous amount of religious references. Although generally fairly ecumenical in the Judeo-Christian sense, but still a tremendous amount throughout American history. Declaration of Independence, and not just kind of the creator talk at the start of the Declaration, but the reference to the Supreme Judge of Nations in the last paragraph of the Declaration, and all sorts of things ever since the framing, and including since the Establishment Clause, partly because of that history, partly because of the total shambles that the endorsement test has ended up, maybe shambles is the wrong thing, but the mess that endorsement test has been just with so vague to try to figure out what endorses religion and what does not. Partly because I just don't like historical bowdlerizing. I mean, the trouble is, if you really take it seriously, you do have to remove the crosses from Las Cruces, New Mexico, which is a city which is the crosses in Spanish. It's not quite blowing up the Buddhas as the Taliban did, but it does have the same notion of going back over history and saying, well, this part of history is no longer politically correct by today's standards. Somebody might be offended. By the way, I should say, I'm not a religious person myself. I'm, in theory, the kind of person who ought to be offended. I'm not offended by this. The fact is, I live in a country which is majority Christian, which has a deep religious history, and I don't want the country to go out there and try to edit out parts of its history. Justice Breyer seemed to recognize that in some measure, in the Ten Commandments case, is saying, well, this monument is old, and that's okay. These things are new, and that's not okay. But that's not really an acceptable principle either. I would much rather that the government not be constrained by the Establishment Clause in this situation, and constrained by kind of a sense of what the public is willing to tolerate and what kinds of things they're going to get criticized for. And if as a consequence some people, including some people like me, feel reminded of the fact that we are in a religious minority in the country, well, so it's not like it's a big surprise to us.
So what would violate the Establishment Clause with respect to symbols, in your view?
I think with respect to symbols, virtually nothing. You can imagine something like an official proclamation. We proclaim Christianity or Protestantism or Southern Baptism the official religion of the state of North Carolina. But when it comes to anything short of that, and if you need a bright line, and if you say, no, I need a bright line, I'd be even willing to allow that on the permissible side of the bright line and leave it to the political process.
So if we have chaplains giving prayers saying Jesus loves us, and
Yeah, I should say
that's fine with you.
Mere
And
symbolism.
we can have creches, right? Because that's, it's majority religion.
Creche is perfectly fine. Another example, first of all, Christmas trees, maybe just part of my background. I was born in Russia. In Russia, there are New Year's trees, which I think is what happened when the communists took over and they wanted to secularize it.
Right.
I love trees. I don't see them as
They had
religious
Comrade
symbols.
Claus, I take it?
Pardon?
They had Comrade Claus?
Not quite Comrade Claus. It would be Comrade Quote. It's Grandfather Frost. And I think the notion that you have to expurgate trees, Christmas trees, from public places, and for that matter, stop people from singing religious carols in celebration of that whenever it involves some government entity, that to me is much more offensive than having a Christian. And if that reminds me that most of my neighbors are Christian and I'm not, I'm essentially a secular Jew, well, that's fine. So no, a creche is not a problem. Now, the chaplains are a little different, partly because chaplains sometimes do have something of a captive audience, partly because they're usually salaried employees, so you've got kind of people hired specifically for the purpose of spreading the gospel. But the court, I think, quite plausibly said this is something that is so much a part of American tradition, dating back to the first Congress that enacted the Establishment Clause, that is something that ought to be tolerated. I do think that preferences for religion in funding programs and in other kinds of programs where somebody gets more rights because they are of the right religion or even religious generally, those are generally something that I'm quite troubled by, and at least in certain situations would be unconstitutional. But it's the symbolism.
Yeah.
I wouldn't mind drawing a crisp line somewhere in the middle, but I think it's pretty hard to draw such a line. And in the absence of such a line, I would generally err on the side of letting the government engage in whatever symbols they want. And if some of us don't like it or some of us are offended, tough luck.
Mm-hmm. On faith, take the example of faith-based initiatives. One of the things that people have worried about is the possibility that money will go, for example, to a prison counseling program in which one of the methods for prison counseling is to try to proselytize, and that it's relatively effective, but that there are no alternatives available to the prisoners that don't involve proselytization. And so
I do think that is a potentially serious problem. Here's where I think it's an especially serious problem. Imagine that the prison and counseling program, if you complete it successfully and you get a good reference from them, you get some time off your sentence. That's sometimes true as to some kinds of alcohol abuse, anti-alcohol and drug abuse programs. And the courts have held that when those programs have a religious component, you can't give people a special bonus for participating in these programs because that's essentially coercing people through threat of continued incarceration, coercing people into participating in a religious program. That does trouble me. On the other hand, here's an example of something that doesn't. Imagine that there really are several different programs, alcohol abuse prevention programs, for example. One of them is religious, others are not. And in fact, some inmates who are religious may feel much more at home in the religious program and much more on board with it. And in fact, they may feel more troubled if they're coerced into participating only in secular programs because the secular programs to them are completely alien to their notions of how it is I should change my life. It seems to me that kind of even-handed program that allows people options, one of which is religious, perfectly fine.
Does that mean then that government contractors who are pervasively religious must provide secular versions of their program until such time as they have sufficient competition in a prison or a hospital?
I think that... so first of all, I think prisons are a complicated matter, especially when it comes to the government not just saying, hey, you guys can have access to this, but rather, if you want to have time off from your prison sentence, or if you want to have extra special benefits, like better living conditions and such, you need to participate in this program. And it turns out that program is religious. I do think there's a possible problem there with the government's being treated as coercing, or with the government's essentially coercing inmates into participating in these kinds of religious programs, especially if it's the only one and the government chose it. There's also a risk that the government may have chosen it in part because it's religious. On the other hand, I think if there are multiple programs that the government chooses on an even-handed basis, I think that there is no problem. Here's the toughest question. Imagine the government has a completely religion-neutral selection mechanism. And what's more, the government doesn't even say there can only be one program in operation at the prison. It says, look, any program that wants to come into this prison, perfectly fine. And we're going to decide based on conditions that have nothing to do with religiosity. But it turns out only one program participates, and that program happens to be religious. I think that would be something that should be constitutionally permissible, in part because, if non-religious institutions want to step up to the plate and provide similar programs, that's great. And if not, then at least you should give inmates one program that seems to be willing to help them, even if it's a religious one. At the same time, I do think that's the toughest example because of the combination of the prison context, where there's potential for real coercion, coupled with the fact that the only option is religious. There, I do think you have at least a stronger claim there's coercion of religion. But just the fact that one of the many programs offered by the government that's indirectly funded by the government happens to be religious, that's no more of a problem to me than the fact that when you've got the charitable tax exemption, or that you can deduct charitable contributions from your taxes. Turns out, my sense is that at least about half, probably a little more, of those kinds of deductions are for contributions to religious institutions. And as any economist will tell you, and most lawyers will tell you, looking at the Supreme Court cases too, those kinds of exemptions are really tantamount to subsidies. The fact that because of private choices, those subsidies are going in part to religious institutions, not at all a problem to me. In fact, if anything, I'm much more troubled by rules that say you can, for example, use this money at a non-religious institution, but not a religious one. That kind of discrimination.
Now, Eugene, I was just going to ask you, though, would there be a problem, in your view, under the free exercise clause, if the government, or establishment either, if the government said, look, you can take our money for a prison program for preventing drug abuse, or you can take our money for a voucher if you're a parochial school, but the one thing you can't do is you can't proselytize, and you can't engage in practices that are derogatory of other religions. And that's you can have symbols up, you can have a cross up in the classroom, you can have all that stuff. But we're going to require that you not do those two things. And that's the condition upon which we give you the money. Would that cause any problem for you?
Yeah, I think it would violate the free exercise clause. I think it would also violate the free speech clause, especially in the context of school choice programs, where you're essentially saying that in order to participate in this generally available funding program, which I think ought to be treated as a designated public forum, you essentially have to not express certain viewpoints, such as viewpoints derogatory of other religions. I think that if schools are free, as they would be, to proselytize environmentalist views, or proselytize feminist views, or proselytize Afrocentric views, and criticize other views, criticize racist views, criticize communist views, and so on and so forth, they should be equally free to spread and try to criticize religious views. This having been said, I have to acknowledge the Supreme Court is not where I am, and in fact, the Supreme Court has taken a different view by quite a large margin. In a case called Locke v. Davey, the Supreme Court upheld a program that essentially allowed college students to use state-provided scholarships for virtually any purpose, any educational purpose, but not to study devotional theology. The court upheld that 7-2, with Justice Scalia and Thomas the only ones who took the view this violated the free exercise clause. I think that was a mistake, but that's where the court is.
You agree with Scalia and Thomas on that?
I do agree with Scalia and Thomas. I think the free exercise clause generally says the government may not discriminate against religious entities, religious speakers, and religious people based on their religion or based on their religiosity. And I think that ought to be true in funding programs as much as it's true in regulatory programs.
So this is, by the way, for those of you at home, you should understand these are the areas where we're a relatively strong disagreement about how to imagine the Establishment Clause and its intersection with free exercise. So Eugene's sort of given you his take on how you do it, and I'm kind of don't agree with a lot of what he just said. And
Jack, you've got 7 votes, at least at the time, 7 votes, maybe even today, still 7 votes on the court on your side.
Yeah, although I suspect that my views are not shared by a majority of the justices either, so we're in the same boat. Just so you understand where I'm coming from, Eugene is skeptical of the endorsement test, but for me, the endorsement test actually makes a great deal of sense. Because if you ask yourself, how does the prohibition against establishment apply to state governments? Since the Establishment Clause is directed originally against the federal government, don't establish a church, leave the states to have their own establishment. If you ask, how does that work once you have the 14th Amendment with its guarantee of equal citizenship, then you have to ask, what part of establishment is promoting the idea of equality of citizens? That is, what does it mean to say that establishment has anything to do with providing equality for citizens? The answer has to do with the idea that the government can't make some people in the country or some people among its citizens insiders, special insiders, because of their religious views, and it can't relegate other people to being outsiders because of their religious views. So when we think about what the Establishment Clause means in light of the 14th Amendment, it's got to be some kind of limit on certain forms of government message giving, government expression about what it means to be inside or outside groups in the country. That means that the government probably couldn't, as I understand the Establishment Clause, proclaim this to be a Christian nation. It couldn't say that it's better to be a Christian than to be a non-Christian, or better to be religious than non-religious. That government basically has to treat all of its citizens equally. And from that, something like an endorsement test tends to follow.
Jack, actually, I think there's a lot to be said for this view, and I think maybe you're right on that I do think that endorsing a certain religion may be seen as establishing it. I probably come out on the other side, but I think there's a lot to be said for that view. This having been said, what do you do about the problem of history? I mean, I'll give you an example. I think 45 or so of the state constitutions mention God in their preamble. The U.S. Constitution doesn't. 45 of the 50 do. Is there an Establishment Clause mandate to go out there and amend all of those? Remove various monuments that are religious? Mm-hmm. Is it that they've become non-religious, or is it that they've become primarily historical? Is it the new versus old?
My view is that if you think that what's really at stake in the Establishment Clause when it's applied to the states is this idea of equal respect and no insiders, outsiders, then what you'd say is that you'd have to have some form of exemptions for very old practices that essentially carry very little social weight. It's largely a social meaning point. And you might even have certain kinds of exemptions for so-called ceremonial deism. But how the extent of those exemptions, historical exemptions and ceremonial deism exemptions, would be based on judgments as to what their current social meaning would be. The example I like to give my students is the following. I ask them, how many of you would be upset at the fact that our currency says, "In God we trust" on it? And almost nobody raises their hands. Usually there are a few students who raise their hands, but almost no one does. And then I said, all right, fine, but now we'd like to just amend the current past statute that says, it'll say the same thing syntactically. It'll just say, we believe in God. Instead of "in God we trust," it says now, we believe in God. And then I said, well, how many of you would be opposed to that on the Establishment Clause grounds? And almost all their hands go up then. Why is that? It means the same thing syntactically, right? The semantic meaning is the same. I've just reversed the syntax, the order. And the reason is because the social meaning of it has changed. It now looks like there's a fresh statement by our government contemporaneously that we believe in God, and to be an American is to be a God-fearing person. Whereas "In God We Trust" seems like a museum piece. It was religious. It was generated by people who had religious views, although in fact they were deists as opposed to the kinds of Christians we had today.
Are you sure that they were deists as opposed to some of them were deists? My sense is
many
quite
of
a lot
them
of them
deists.
were very
many of them
solid
deists, and some of them would be regarded as completely godless by today's standards. You remember Jefferson's work trying to strip the divinity of Jesus out of his version of the New Testament.
Jefferson was the one who drafted the Declaration of Independence, which talked about the Supreme Judge of Nations. So either he believed it at the time, or he didn't believe it, but at the same time didn't see that as a statement, didn't see that kind of quite religious statement as a statement that suggested somehow the inferiority of non-religious.
Right. And so what these things mean, if you take the endorsement test seriously, is that social meaning counts, how things appear counts, and that I think was true in what Justice O'Connor's work was about. I think it's also true, and to a certain degree, in Justice Breyer's splitting of the difference in those two Ten Commandments cases.
And how they appear to Jack, or how they appear to Eugene?
Oh, well, obviously I would go with Eugene on this, since Eugene has a much more sensitive view of the world than I do on many things. But Eugene, I take it that what you're pointing out to is the major problem with the endorsement test, which is that it requires that you are willing to trust some group of people to give a relatively neutral account of what social meaning is. And social meaning is heavily contested in a country as religious as America is. But I think that even though there are difficulties with the endorsement test, I think there are, and you named them, I think that, in fact, it's the best way of making sense of what the people did in Reconstruction when they decided to put an equal citizenship principle in the Constitution. It's the best way to understand it.
That's a plausible view, and I said maybe it's even the right view. This is not an area, as I said, that I feel very strongly about.
And then the other issue that you and I were talking about, which is what do we do in a situation where the government distributes benefits for programs, social services programs. And my view is simply that the Establishment Clause was drafted at a time when government did very little of what we now call the welfare state, that is, using its spending power in order to govern, to provide social services. And now it's just everywhere. Government licenses, government employment, government social programs. That's a standard method of government getting around, doing its business today. The Establishment Clause must be understood in light of a world in which that's how government governs. It governs through spending money. And in that world, it can't be the case that we can completely shut out religious programs providing social services. On the other hand, we could require of them, without violating free exercise, this is where you and I might disagree, that they have to provide what are equivalents to what secular organizations would provide in the way of social services. That would mean that we might say that as a condition of being a government contractor, you have to provide what are effectively secular services, even though you're a religious organization. We might even allow you to have religious symbolism in the walls when you go in. I mean, we might say that's fine. But what we might want to do is to say that because we are saying that you're providing services just as good as a secular provider, we're going to say that one thing you can't do is proselytize. And we're going to say that where it turns out there's only one provider of a service, where it might require more of you than we would require if, in fact, there are a lot of competitors. That's my view of how we would do it, and I don't think it violates the free exercise clause to do that.
So let me ask you this, Jack. Again, I think if the court adopted simply your view, I wouldn't be terribly upset because I think, on balance, it's not that far from where I am on this. But let me ask you this. The single biggest benefit that religious institutions get is indeed the subsidy that is provided to all charitable educational nonprofits, charitable and educational nonprofits, through the income tax charitable contribution exception. Imagine that Congress took what you said to heart and said the following: we're going to exempt any kind of contributions for charitable and educational purposes. So if you want to contribute to the non-lobbying, non-electioneering arm of, say, the ACLU or the NRA or whatever else, perfectly free to do that. And we will not just free to do that, but we will provide kind of the matching grant that is provided through the charitable tax exemption. However, if you want to contribute to a religious institution that will use some of this matching grant to proselytize, no. That's not something which is entitled to the charitable tax exemption. So we're then going to have to decide whether what these kinds of institutions are. But basically, any subsidy to groups that promote non-religious ideologies, or not subsidy, any donations to groups that promote non-religious ideologies, perfectly fine, eligible for this generally available subsidy. But if your group promotes religious ideologies of the group to which you're donating, that's not fine. We're not going to give them the subsidy. Permissible, even mandated?
Yeah, I think that one is different than the prison example. My view of what good policy is I actually think the contribution for charities isn't a bad policy. There could be other ways we could do it so that, in fact, poor people do better than they currently do under the system because, as you know, the deductions mostly help rich people as opposed to poor people. And there are ways through a voucher system, for example. Well, for example, if I'm at the 40% bracket, 40% of my donations are covered, whereas if I'm a poor person, less of my donations. So that's the effect.
Well, but
we can do that.
That's the example of the baseline issue, right? Well, so since you're a rich person, you're paying 40 cents out of every dollar, and the poor person 15 cents. I'm not sure it's so much that it helps you so much that we will essentially deduct from your taxable income the amount that you've given away and that you're not having in your pocket, and therefore you have to pay 40 cents on fewer dollars, whereas the other person has to pay 15 cents on fewer dollars.
If you had a somewhat more egalitarian view about the purpose of the charitable deduction, you might move to a voucher system instead of the tax deduction system, because the voucher system would allow everyone to donate a certain amount to the religion or the charity of their choice, which would put everyone on a more equal playing field. But I don't want to get into this very interesting policy discussion. I want to get back to your point about that. There's a difference when the government hires someone to perform social services, and the kinds of restrictions government might place upon them when effectively what they're doing is helping the government provide its social services like its anti-drug abuse program in a prison. And when the government is engaged in what I regard as a more general information policy, which is we want to promote the spread of of information. We want people widely to be able to state the views that they state and to organize and associate with themselves for doing that. When you do the second as opposed to the first, there's more of a limit on how the government may restrict its use of funds than in the first case.
I'm not sure that that's a sound distinction, but again, it's a plausible distinction. We are not on the same page here, but I don't think we're that far apart, and I think there's a lot to be said for your position.
But we are on the same page with respect to this question, which is that we're about out of time, and we're going to have to take up the third, fourth, fifth, and so on amendments at another time. Anyway, it's been a great pleasure talking to you, Eugene. And,
great pleasure talking to you as always, John.
I hope we can do it again soon.
I hope so.
All right, bye-bye.